Hunter Biden, indictment coming soon. That's what they tell us. We're going to look at the actual update from the prosecutors that revealed all of this to us. They say the indictment will be here by September 29, 2023. And the reason for that, we've got some speedy trial rules. We've got some criminal procedure guidelines that they have to fit within. Otherwise, they might lose the opportunity to even indict Hunter at all. But this came about because Judge Noreika issued a status update. She said, I want to know what you're doing, government. Stop dragging your feet on this. And Hunter's lawyers also provided an update as well. So we'll take a look at both of those. But this is what CNN sounded like when they broke this. This is Wolfie gets excited about breaking news.
And there's more breaking news just coming into CNN right now. The special counsel, David Weiss, intends to seek an indictment against Hunter Biden relating to gun charges by the end of the month. That according to a new court filing. Biden had previously reached a deal involving a gun possession charge in court. The future of the gun deal has been in limbo.
So we've got a lot of questions. One was supposed to be resolved in a guilty plea. The other was going to just evaporate the gun charge. And as part of that gun charge, there was a very broad immunity provision that immunized Hunter from all sorts of prior conduct in his earlier years. And the judge asked a couple questions about that. The whole plea deal went awry when Hunter was not able to really answer a question appropriately. And so the judge issued this order saying, hey, look, on August 31st, says in view of the Speedy Trial Act, this is the judge just going through her calendar. She's sitting there with her court clerk. What's going on with the old Hunter case? She says, I haven't seen anything from those guys. So it is hereby ordered that on or before Wednesday, September 6th, parties are directed to provide the court with an update on the status of this case, including any steps they believe that the court needs to take, ordered by Judge Noreika, Delaware Court. And so, all right, she says, I kind of want to see what's happening here. You guys are you going to, government, allow another statute of limitations to expire so Hunter doesn't get charged again? What are you doing? So two updates come in, and the first one is from Hunter's lawyers. Pretty simple from them. They say, all right, well, they basically think that Hunter is innocent right now. They think that the diversion agreement was already executed, but this is very short, one-page filing over to Judge Noreika, District of Delaware, coming from Abe Lowell, Hunter's new lawyer out of Washington, D.C. Says the following, all right, Your Honor, defendant Robert Hunter Biden, pursuant to the court's order, hereby provides a status report that you asked for. On June 20th, the information commencing this case was filed in Delaware, and the court was subsequently provided executed copies of the parties' diversion agreement by counsel. See this? Executed copy of the diversion agreement by counsel. Executed, meaning they think it's already executed. Mr. Biden has been following and will continue to follow the conditions of that agreement, which the U.S. Attorney's Office agreed and signed and informed the court on July 20th that the probation office had agreed to and recommended be put into effect. A diversion agreement, which to our knowledge was never actually executed. And the government said the same thing, but Hunter's lawyers are still just playing along. No, we signed it. So they're going to act as though it's already been executed, which, as we know, the diversion agreement included the blanket immunity. So Hunter's team says, no, Judge, there's really no reason to even give you an update. We already think this case is closed, is what he's saying. It's already done and over. He's already following the agreement. He's already following the terms, even though nothing was ever actually entered in court. But they're saying this is a private agreement between Hunter and the Department of Justice. So the judge needs to be kept out of the whole thing. She's not even pertinent. Thanks, Judge, for asking for a status. We've already been taking care of it. So let's see what the government says. They respond. Here is the government status report. They say, all right, filed on the 6th, 3 pages, a little bit longer. United States' status report in the case says the government prosecutors from David Weiss's office, and you see here who is signing this one. This is Leo Wise, who is the same prosecutor who was there at the plea deal. And, these people were behind the whole scam deal in the first place. The fact that they're still working on this is like a joke. They should have all been fired immediately for concocting a scam deal. But here's the point. They kept him on. They actually gave David Weiss a promotion, and they say, all right, Your Honor, the United States, through our so-called prosecutors, submits this status report pursuant to the court's order. You said, in your view, the Speedy Trial Act, it's ordered that we give you an update. And so that's what we're doing here. Government says, U.S. Code, commonly referred to as the Speedy Trial Act, says the following. Says, Your Honor, any information or indictment that charges a person with a crime shall be filed within 30 days from the date on which the individual was arrested or served with a summons. Fancy way of saying, if you get in trouble, they've got to charge you within 30 days or bring the indictment or bring the information, right? They can't just delay this indefinitely. In this case, they say, defendant was charged via an information with violation of firearm law. He was also charged with a tax violation on June 20th. So these are the starting dates in a separately docketed case. The government filed a letter in both cases in which, on behalf of itself and the defendant, asked for a consolidated initial appearance on the firearm information and a change of plea hearing on the tax. The government stated stated in that letter that Hunter had agreed to plead guilty to both counts of the tax information, and a pretrial diversion agreement would be entered. On June 8th, prior to the filing of the two informations, the parties provided the court with copies of charging documents and an unexecuted draft of a memorandum of a plea agreement, unexecuted, related to the tax information, and an unexecuted draft of a diversion agreement. So unexecuted, okay? The government still says, we never executed that at all. On June 21st, the court issued an order scheduling this hearing for a matter in July. According to a sealed entry on the docket, which we don't know what it is, Hunter got a summons. On July 26th, the court conducted an initial appearance and set release conditions. At the hearing, Hunter waived a preliminary hearing. The court also deferred a decision on the plea and the pretrial diversion agreement. I know this is super technical, but this is a weird case. Like, this case didn't go through the ordinary process. Normally entered by information, and now we're trying to reverse and figure out what they did, so we make sure we don't violate any of the rules. Finally, the court ordered time is excluded from the Speedy Trial Act between today and early September in the interest of justice. So they tell us, as Your Honor, as this court knows, Hunter did not plead guilty on July 26. He pled not guilty instead. The government informed the court that the parties' attempts at resolving this were unsuccessful, and there was not going to be a proposed plea agreement that was going to happen. In its June letter, the government stated that executed copies of the memorandum would be submitted in advance of the hearing. An executed copy of the plea agreement was provided to the court, but U.S. probation declined to approve the diversion agreement, so an executed copy was never provided to the court, right? They're still saying, Hunter, you don't have a diversion agreement. But if they say, if some other court says that Hunter does, if a court of appeals says, yeah, you do, then he's immune, just like that. The Speedy Trial Act excludes delay reasonably attributed to any period, but because the proposed agreement was provided to the court on June 8th, that agreement was under advisement. The proposed diversion agreement was under advisement from the date the case was formally initiated up and through the hearing, so he's doing his calculation. 30 days from the execution of the summons should therefore be excluded, meaning that the speedy trial clock actually began to run on July 24th. You excluded time, Judge, between this month and this month. Thus, from June to September, only 2 days have elapsed for calculating the 30 days within which an indictment must be returned. Thus, the Speedy Trial Act requires the government must obtain the return of an indictment by a grand jury by Friday, September 29th at the earliest. The government intends to seek the return of an indictment in this case before that date, and the government does not believe any action by the court is necessary at this time. So, Judge, hang tight. We are going to indict him. We've got plenty of time to do it. They say September 29th is going to be the deadline, and that something will be coming down the pike. Now, I don't know what it will be, if it's going to be the same thing. Is it going to be misdemeanor tax charges? Are they going to charge the gun crime? Are they going to charge felonies instead of the misdemeanors? Are they going to charge the actual criminal conduct that this guy is responsible for, namely 600 pages of it? Or is it just going to be his tax compliant nonsense? So that is the response from the prosecutors to the judge, and we know that there's going to be a lot of open questions about this. Even though the indictment is coming soon, what is it going to look like? This is what NBC News has to say about it. And you remember this guy, he was reporting outside of the Hunter Biden plea deal courthouse when the whole thing went awry, and he was out there like, what the heck is happening here? He has some inside knowledge about what's going on.
Tom, explain this to us. Do we have any sense of what the potential charges against Hunter Biden could be?
Sure. I think it's going to be a lot of what we've spoken about before and what you and I were both talking about outside the courthouse before that plea agreement dissolved, Ryan. I think you're looking at a case here that's going to be based primarily on tax charges. They're going to surround the years 2017 and 2018. And I think the question now is whether or not Special Counsel Weiss will indict using misdemeanor charges or whether there'll be felony charges. And I think based on what they've telegraphed, it's possible that felony charges could be in the offing here. And then we have to figure out where those charges will be filed. He could file them now that he is special counsel in any district that he chooses to that has venue. That's the first thing he has to prove. And so the most likely scenario here that these charges are going to be filed in the Central District of California in the Los Angeles area, because that's where he will likely allege that this conduct primarily took place. So that's what we should expect between now and September. There's still a little bit of a lingering question as to this pretrial diversion agreement on the gun charge, being in possession of a gun while using narcotics. Now, that's where it gets a little bit tricky, Ryan, because Hunter Biden's attorneys have argued that that agreement is still in place because both sides signed it. Federal prosecutors say, well, not so fast. It didn't get the final signature that it needs from probation. Now, you might say, all right, Tom, well, like the tax charges in that plea deal, doesn't that just all go away and they'll include that in future charges? But there raises a bit of a legal question because that specific charge in statute has been challenged quite significantly way in the federal courts and in the appellate courts of this country, and it has been beaten down. So the question as to whether or not prosecutors in a good faith could bring that charge against him remains very much an open question as to the terms of that agreement and whether it's in place as well, because there's clearly a dispute between both parties. So that's something that we're going to continue to have to watch. And then obviously any indictment itself, but it's now a foregone conclusion, according to prosecutors, that the son of the President of the United States will in fact be indicted, will be in court, and will be arraigned at some point.
Yeah, we'll see if there is anything significant that comes in those new charges. I'm not so sure of it, but it is something that feels just like a total scam. I mean, if Hunter gets immunity here because the DOJ engineered, they broke this thing down, in other words, you can make a lot of money in a mess. You can do very well in a mess, right? People can crush it when there's a lot of gray area. And if Hunter's lawyers were able to create enough gray area and the DOJ was so, incompetent or complicit that they just allowed this deal to be signed that will somehow be argued to give him blanket immunity for all of his nefariousness, that is malpractice, that is unethical, and there should be some serious consequences for that. Will that happen? Time will tell.